There's a new ruling from the Supreme Court that limits the crimes that can lead to near automatic deportation. That's awesome news. Hi everyone, I'm immigration attorney Andres Mejer. If you don't know me, I'm an immigration attorney based in New Jersey and an immigrant myself. We help people all across the country and across the world come into the United States legally. Like a lot of you, maybe like some of your friends and family, I had a really hard time dealing with immigration, trying to achieve legal status for me and for my family. We got ripped off by a lawyer that was supposed to help us, but only took our money and wasted our time. And that's what motivated me to become an immigration attorney. I want to avoid people like you to experience all the troubles and suffering that my family and I had. And I want to help you get your legal status with less amount of time and the less stress possible. We have a lot of interesting topics to cover in this video, so let's begin talking about the new Supreme Court ruling that will limit the crimes that could get an immigrant deported from the United States. On Thursday, June 10th, the Supreme Court issued a decision in a criminal case that will have an immediate impact on immigration law. This decision set up a list of crimes that can be considered an aggravated felony and could be a ground for deportation. First, what is an aggravated felony? Well, an aggravated felony is a term used to describe a category of offenses that carry particularly harsh immigration consequences for non-U.S. citizens convicted of certain crimes. When a non-U.S. citizen is convicted of a felony, regardless of his or her immigration status, so that means whether they're a student visa, whether they're a green card holder, if they are convicted of an aggravated felony, they are prohibited from receiving most forms of relief that would spare them from deportation, including asylum. And it could prevent them from ever being admitted to the United States in the future. If this happens, an immigration judge has the obligation to order this person's deportation. It won't matter how long the person has lived in the United States, whether they have close family in the United States with legal status, whether they have deep ties to the community, or whether they are now a good person who has been rehabilitated. Despite how harsh the name sounds, an aggravated felony does not require for the crime to be aggravated or even a felony. Instead, this is simply an offense that Congress labels as an aggravated felony. And today, it includes many nonviolent and seemingly minor offenses that, when the term was initially created, could not have been imagined. There are three basic categories that fall under an aggravated felony. There are certain crimes that are almost always an aggravated felony. They do not depend on the loss to the victim or the sentence the offender receives. Crimes in this category include, but are not limited to, child pornography, disclosure of classified government information, drug trafficking, human trafficking, kidnapping, lewd acts with a minor child, owning or running a house of prostitution, rape, and treason. Some crimes count as aggravated felonies only when the offender receives a jail or prison sentence of at least 1 year. Crimes in this category include bribery, burglary, counterfeiting, a crime of violence, forgery, obstruction of justice, perjury, racketeering, in other words, RICO violations, receipt of stolen property, and theft. And lastly, some federal and state white-collar crimes are aggravated felonies only if the victim's losses exceed $10,000. These include fraud, money laundering, and tax evasion. Now that we specified what is an aggravated felony and what types of crimes can fall into that category, let's discuss what changed in this new Supreme Court ruling. The case is Borden v. United States, where a divided Supreme Court held that for a crime to be considered as a violent felony under the Armed Career Criminal Act, it would require for the perpetrator to have either, one, an intent to use violence against a person, or number two, the knowledge that they will subject a person to violent force. So either they want to hurt the person, or they know that the person is gonna be subjected to violence. If one person has 3 or more felony convictions, this person may receive a much longer criminal sentence in the criminal case. But a crime committed by only reckless behavior is not enough. So a crime usually has what's called a mens rea, which is an intention. So there's different levels of intent. Did I do something on one version? On one side, it's I accidentally knocked into someone, causing them harm, versus on the other side, I intended to cause them harm. I purposely tried to hit them and did hit them and cause them harm. Well, reckless is in between. Reckless is a legal term that most commonly means when a person consciously disregards a substantial and unjustifiable risk. So, criminal acts have a mens rea, an intent element, and some physical action. You typically need both. Right now, we're talking about the intention that would rise to the level of aggravated felony. One example of reckless behavior is driving a car too fast through a busy neighborhood to get to work on time. The driver does not intend to hurt anyone and does not know for certain that they will hurt someone. Instead, the driver acts without thinking about the serious potential consequences. The decision made in the Borden case has a huge impact on immigration law, because the violent felony definition in this federal criminal statute is almost identical to the definition of a crime of violence in immigration law, and crime of violence is one of those terms that are considered an aggravated felony. As we saw it a bit earlier, a crime of violence is one of the many types of aggravated felonies that can make a person deportable. With this decision, an important limit was put on the broad crime of violence aggravated felony definition. The focus was set on 2 key words in the definition of violent felony that is nearly identical to the crime of violence definition. A crime of violence is an offense that has an element that attempted use, or threatened use of physical force against a person or property of another. Whereas a violent felony has the same definition, except it does not include property. So crime of violence could be against a person or against a person's property, and a violent felony is only against a person. Otherwise, it's the same terminology. Justice Kagan, joined by Justice Breyer, Justice Sotomayor, and Justice Gorsuch, wrote that the use of force against a person requires that the perpetrator target another person. Justice Thomas provided the 5th vote. He wrote that the use of physical force requires that the perpetrator intentionally act to cause harm. These decisions make sense. As Justice Kagan explained, violent felony and crime of violence are supposed to be limited to the most serious types of offenses. This is typically true given the devastating immigration consequences of having an aggravated felony conviction. All of this may sound confusing, and it may sound like it's not much of a difference, but the key part to take from this is clarifying these terms, the differences between them, and setting up the limits they have is a huge change and can be the difference between getting automatic deportation or not. So a crime of violence, what this decision is saying is, hey, you may be convicted of a crime under a federal or a state statute. Immigration then has to interpret the terms of that statute and determine, well, under federal law, is it an aggravated felony or not? Is it a crime of moral turpitude or not? With the aggravated felony, in the past, reckless conduct was sufficient. What this case says is, hey, in order to constitute a crime of violence as an aggravated felony, you, the immigrant, the perpetrator, must intentionally try to harm another person. You can't accidentally harm another person and be considered an aggravated felony. You can't ignore the chance that you might cause harm. You must intend to cause someone harm. If you don't intend to cause someone harm, it is not a crime of violence, even if you go to jail for more than a year. That kind of clarity is amazing for immigration purposes. And anybody that has been convicted of a crime of violence and consequently an aggravated felony might want to look at their scenario, and you may be able to change the outcome depending on where you are in the removal process. If you want to have a specific evaluation of your specific case, give us a call. We will evaluate it in light of the new case law. That's all the time we have for today. If there are any particular topics you would like me to talk about, leave a comment below. Let me know what's on your mind, and we'll try to give you an answer either in a future video or reach out directly to you. Remember, I'm here to help you. It's my pleasure to help you with any doubts or problems you may have. If you know someone who could find this information useful, please share it with them. It would mean the world to me. If you want to talk about your specific case, don't hesitate to contact us. We'll find the best solution for your situation. And if we can't help you, we won't take your money. That's it for today. As always, stay healthy and be well.